What's up, guys? Thanks for joining me. Can you guys hear me? Make some thumbs up, some hearts if you can. Hey, Daleen, great to see you this week. Great to see you this week. Finally meet. All right, guys. So we're going to talk just briefly, reiteration of the same stuff we've been talking about. I just, one thing is I heard earlier this week someone say that oh, he is fighting for the family, and I just kind of want to say that that's what I've been doing all along here, you guys. And whether you can see it or not yet, you guys will soon, all right? Because this has always been about the family. I mean, and I keep on saying that to you guys. I've been saying that for years now. We're using the indictment by a grand jury issue for a very specific purpose, a very specific reason, okay? The indictment by the grand jury is what is called an enumerated constitutional right. It's enumerated because it's written in the Bill of Rights. It's written in the Constitution. You can see it right there. It says no person shall be held to answer for a capital or otherwise infamous crime unless a presentment or indictment of a grand jury. That's enumerated within the first 10 amendments. The Bill of Rights is the first 10 amendments, guys. That's what it is, the first 10 amendments. So there's a difference between an enumerated constitutional right and an incorporated constitutional right. The right to intimate association, the right to have a relationship with your family without governmental interference, that was found to exist by the Supreme Court in 1986, protected under the First Amendment. That is an incorporated constitutional right. It's not an enumerated. And there's a difference between these two, significant difference when it comes to fighting for these rights. You see, we're not going to go into the validity of the 14th Amendment, but I will say once again that I don't care whether it's valid or not. We're going to win either way. Okay, we're going to win either way. And guys, please share this video. We have 8 people on. We should have a lot higher numbers than that. You guys know that as well as I do. The reason why this isn't happening yet, the reason why we're not moving it is because I don't have the backing that I need to be able to get this information out. We need these numbers a lot higher than they are right now. You guys all know this. We got to get these numbers up. So please share, please like, please continue to put this out on the page. If you tap, that's going to continue to put it out on the For Your page until they decide to restrict this account, this video once again, which they seem to have a tendency to do. But there's a difference between enumerated constitutional right and incorporated constitutional right. Now, again, I'm not going to argue the validity of the 14th Amendment. We'll win either way. The reason why is if they say the 14th Amendment isn't valid, right, because it was never properly ratified, that's cool. That's fine. Because the 14th Amendment was ratified or allegedly ratified in 1868. The case that we're dealing with is from 1887, her of California. 1887 is obviously after 1868, and she just wait in his court used the 14th Amendment, first provisions in it, in order to make that decision. Therefore, if the 14th Amendment isn't valid because it wasn't properly ratified, that means her Congress California is not, because they relied upon it to make that decision. Which then we're once again back to an unlitigated issue because the Supreme Court has never made this decision because they made it in 1887 after the 14th Amendment was allegedly ratified, and so we win that way. But if we win under the validity of the 14th Amendment, we will under the Privileges and Immunities Clause all day long. The reason why is because the 14th Amendment says no state shall create or okay? The United States you got to go to two places, okay? First off, there are two different privileges and immunity clauses within the Constitution. One is in the body of the Constitution under Article 4, okay? Now, Article 4 doesn't say what those are because Article 4, of course, is the duties, responsibilities of government. I keep telling you guys, Articles 1 through 7 have no rights within them. Those are duties, those are obligations of government. So Article 4 can't say what those rights are because if they did, that would mean that the rights and the duties came at the same time. That's not true. So what Article 4 says, it says that the citizens in each state shall be entitled to all privileges and immunities as the citizens in that state. What this particular provision in the main body of the Constitution did is it formulated the concept of egalitarianism, which is the belief that all men are equal. Well, in order for all men to be equal, governments and laws must treat them equally. That is an egalitarianism, which means that if you have a privilege or an immunity in one state, you can't be denied that privilege or immunity in another state because that would mean that the laws are applying unequally amongst like members of our society. You can't have that, not an egalitarianism form of government. You see, these states have got it all wrong, and we're going to beat them pretty handily. But, you know, let's just use an example. Let's come up with one. Right now, today, you can go to the state of Oregon, and the state of Oregon has said, we are not going to prosecute for drug possession. You can possess any drugs whatsoever that you want, your heart content, right? And I'm not advocating for this to be good, but I'm saying this is an example of how you guys can fight back, right? If the state of Oregon has created a law that says, oh, yes, you can have the possession of drugs, right? In a certain quantity, possession level, right, for your own personal use, then that is an immunity that the state has created, an immunity from prosecution. It's not a privilege because you don't have the privilege of being able to have drugs, right? Because the federal government still has, you know, the drug enforcement laws, so you don't have the privilege to have it, but they're not going to prosecute you for it. That is an immunity, all right, an immunity. So if Oregon says, well, we have a law and we're not going to prosecute, guys, how the egalitarianism form of government works, how Article 4 works is no one within the country can be prosecuted for drug possession, right? Because the citizens in one state are entitled to immunity, therefore the citizens in all states must be entitled to the exact same immunity. Pretty simple, right? Okay. So, but this hasn't been challenged yet. I'm not saying that this is, don't go out buying whatever it is that you're buying because we don't yet have this particular challenge in place, but that's just an example. Now, this also came from a case called Oglethorpe versus Hodges, right? United States Supreme Court. This was sometime around 2010. And what happened there was they got married. New York said it was completely lawful to be married as a gay couple, and as a result, they were married lawfully by the state of New York. But then they moved to Ohio, and Ohio said, "Oh no, we don't have gay marriage. We don't recognize your marriage from New York." The full faith and credit clause. We're not going to accept, you know, what happened in the state of New York, and they challenged it to the Supreme Court. They won, and it was there. So, it doesn't, Daniel, but Bill already get heard. So what Daniel said over here, he says it takes a few more states, citizens of several states, before we reach that point. It doesn't under the Constitution. One state is sufficient to be able to make it apply. But you're right. In order to make this work, the United States is going to make a decision that's going to correct it. Now, the problem with the Supreme Court is that they don't want to make decisions because they claim this whole states' rights, this abstinence or this abstain policy that they have. They say, yeah, you know, we don't get involved in state issues. Right? But nonetheless, this is what they do, right? This is what they do. So the Supreme Court says that we abstain, and you know, like in the case of Brown versus Board of Education, we're challenging Plessy versus Ferguson and segregation in the South. You know, that was Brown versus Board of Education of Topeka, Kansas. They only had one state, right? NAACP came up. They were challenging one single state, and they weren't getting anywhere, right? They weren't getting any traction. It wasn't until they enjoined 2 more states in the litigation that they won. Now I'm going to tell you guys that right now today we have 42 states enjoined, right? We have 41 states enjoined. Today we're going to have 42, and so I'll come back to your statement there. Lawyers are part of the problem. Lawyers are the problem, not part of the problem. They are the problem. But we got 41 states enjoined as of this moment, right? 41 states that we can show are acting in a very specific manner to provide people in the United States their rights, their as fundamental by the United States of America, the Constitution of the United States. That's a big fucking deal. Right? But again, what I'm doing is I'm creating a single procedural situation that applies to a massive number of people so that this be heard. Right? So we've got to be heard. Right now the court is ignoring me. You all know that. They can clearly hear what I'm saying. Right? They know what I'm saying. I had a Secret Service and an FBI dossier on me. They're watching everything I do. Great, awesome. If they're watching what I do, they're watching these videos too. And if they're watching these videos, then they know the argument that we have. They know the validity of it. They know how powerful it is, and they know that they're going to fucking lose. They're going to lose all day long, which is why they are ignoring me. Okay. Great, ignore me. They can ignore me all they want, but that doesn't mean that we're not going to be heard, right? Because once again, like, you can't go around the country and serve 41 state attorney generals, 41 state Supreme Courts with actual real and true actual victims of persons. Which is why this on this issue. They're all day long on this, right? But that's why they hear us, because the moment they have to going to hear is actually it's indicative of us being in, right? And I've been saying this as well, that behind me, right, is that a state cannot be both accuser and judge. They can't. That's why in Article 3 of the Constitution, which his own body works with is the in all cases in which a state Supreme Court shall have original jurisdiction. Original jurisdiction and if I'm in he might realizes that he works for the state of Washington, right? The first thing he must do is he must recuse himself, because the state of Washington is the plaintiff. He has a conflict of interest. He works for the plaintiff. Simple concept. So, but the thing is that there are 2.9 million people currently in prison here across America today. Every single one of them have been charged with a crime by a court that did not have jurisdiction to be able to oversee that particular dispute. And that includes the federal side as well, you guys. It includes the federal side. The reason why is because if the states make the laws and bring the accusation, the federal court must be the judge. That's why in all cases which a state shall be party, Supreme Court shall have original jurisdiction. That's why Alexander Hamilton wrote in the Federalist number 80 that the federal judicial authority must extend to all cases between a state and the citizens thereof. If there's a dispute between a state and the citizens within that, then guess what? The federal judicial authority must extend. The federal courts must be the judge if the state brings the accusation. But what about if the federal court or the federal laws are brought against you in an accusation? Well, according to Article 3, the trial of all crimes, with the exception of impeachment, shall be by jury, and the trial shall occur in the state wherein which the crime is said to have been committed. Because if the federal government brings an accusation against you, that federal judge has no authority to oversee that dispute, because Article 3 says that the state must be the judge. The way that our system was designed to work, right? The way it was designed to work was that the United States of America made the laws. That's why Clause 1, Article 1 of the Constitution says all legislative power shall be vested in a Congress of the United States consisting of a Senate and a House of Representatives. All laws, all legislative power was vested in the central government, man. Right? Central government. They were to make all the laws, and then they would federate them out to all the regional governments for application and administration. That's what a federal justice or federal system is a federation where the central government creates the laws together so that all laws are equal, so that all men are equal, so that the laws apply equally to all persons across the entire nation. That's the way it was designed to be used, right? The central government was represented by all of the regional governments. They came together, equal representation. They make the laws, and then they federate them out to all the regional governments for application administration. That's the way it was supposed to be. Therefore, your accuser was supposed to be the United States of America, and that way the judge, who represents a different government, can be neutral and biased because he's not profiting off of the involuntary servitude of the person being enslaved by the accusation. You have to have a separation of powers. You have to have a limited government. And right now today we've got unlimited government because the state seems to think that they can create the laws, that they can investigate those laws, so that they can accuse you of breaking those laws, so that they can judge whether or not you disobeyed the laws, and then so that they can profit off of your involuntary servitude in a for-profit state-run industry for the direct benefit of the state. There's no limited government in that. Same thing with the federal government. You got the federal government who creates the laws, who investigates whether or not you broke the laws, who charges you with a crime for having broken those laws, who judges whether or not you broke those laws, and then who profits off of your involuntary servitude in a for-profit business for the direct benefit of the federal government. No neutral, unbiased decision makers involved in this process, and especially when they remove the indictment by a grand jury. Are you serious? The purpose of the grand jury is to protect the accused from hasty or malicious charges from an overzealous prosecutor. Guys, that's the purpose of the grand jury. Look it up. The purpose is to protect you from a prosecutor. And yet the prosecutor is abusing their power by denying you, the opposing party, the right to be present to confront the accusations against you in a proceeding that's there to protect you from the prosecutor. Are you fucking serious? It doesn't take a rocket scientist to understand that this is wrong, right? That this is unconstitutional, that this is an abusive process, it's abuse of discretion, and it is producing a void outcome because that prosecutor commits a crime every time he denies you your right to be present to confront those hearsay accusations against you. You were supposed to be present because that is a proceeding that's there for your protection, right? As the accused. And anytime the government commits a crime in the pursuance of an outcome, that outcome is always going to be unlawful, unconstitutional, because it drives from a criminal act. You can never have a criminal act produce a lawful outcome. You can never have an unconstitutional act produce a constitutional outcome. If you break the law of government in the pursuance of an outcome, that outcome is going to be unlawful because it drives from an unlawful act. There's no denying this, guys. None whatsoever. So what you guys need to understand here is that you were supposed to be present. to confront those accusations against you in that grand jury, you're always supposed to be present. In fact, we even have a case from 1887 that might be a year that you guys are keying in on, because in 1887, the Supreme Court of the United States decided that the state of California didn't have to do an indictment, that they could charge by way of information, and thus they sided with the state of California's Constitution, not the United States Constitution. But that's an interesting year for me to say that same year we have a ruling from the United States Supreme Court that tells us exactly how a grand jury is to be ran. That case is called Hurtado versus California. The very case that said that we don't get an indictment by grand jury is the very case that you guys can use to say, no, you know what? I was supposed to be present, and you committed a crime when you didn't permit me to be present by not informing me of the proceeding and proceeding without me. That is a fact. Because in the case Hurtado versus California, if you guys go out and read it, go out and read it, right? In the case Hurtado versus California, what they say, they describe the grand jury process within it. And again, this is the United States Supreme Court. This is the very case that says we don't get an indictment by grand jury. In it, they describe the process, and in it, what they say is they say that the accused is present, has the right to counsel, and can call and cross-examine witnesses. Why is it that in Hurtado versus California, they say that you are present in that grand jury, you have the right to have counsel with you, and you have the right to call and cross-examine witnesses? Because you're always supposed to be present in that grand jury. The state can't deny you your right to be present to benefit from the very proceeding that exists for your protection from the prosecutor. Guys, we have a pretty major issue going on right now. I don't have the proof of it quite yet, but we're getting close, right? None of these indictments are valid. Every single one of them are illegal. Every single one of them are illegal, right? Because did you know that none of the grand jury foremans are signing these indictments? Every single indictment is signed by the prosecutor. The prosecutor. So your opposition, right? The accuser's counsel is the one signing the indictment. They're the one that's presenting the hearsay evidence. Evidence is not even admissible in a petit jury in order to secure whatever charges that they want. They're the one that's denying you being present. They're the one that's refusing to give you the transcripts. And they're also violating the rules of civil procedure by not having the grand jury foreman sign these indictments, and they're signing themselves. It seems to me like the executive branch has taken over a proceeding that was our proceeding, that we never delegated the authority to the executive branch. And now the prosecutor is the one signing every indictment. They're the ones that prove whether or not a crime is committed. It was not delegated to reserve the people, because the grand jury was supposed to be a neutral and biased proceeding by the people that had no control by the judicial branch or the executive branch. The rules of civil procedure say that the grand jury foreman must sign those indictments, and yet guess what? None of them are being signed by a grand jury foreman. How many of you get a copy of your transcripts for your grand jury proceeding? None, right? None. So let me ask you another question then. How can you prepare a robust legal argument if you don't know what the accusations are against you? Why is it that you don't have those transcripts at a minimum, right? I mean, you're supposed to be present, but how can you prepare a robust legal argument against criminal accusations when you don't know what those criminal accusations are, because you've never been given the transcripts? In fact, we're being told across the board that transcripts will not be released without a judge order, if they even get released. And I guarantee you that 90% of you don't have a grand jury transcript at all. And the reason why is because they're not running them, you guys. They're not running them. Think about how many indictments a grand jury could issue in one day if they heard the accusations, legitimately heard them. They heard the evidence against you. How many of them could they run a day? And yet look at the numbers that are being passed through every single day in these states. We have some of these precincts, some of these larger justice systems, these sheriff's departments. I mean, they're doing 3,000 a month, right? There's no way that a grand jury can be passing 3,000 a month through. So those aren't indictments. Those are information signed by the prosecutor that they simply titled indictment. Information because the prosecutor signed them. Because there is no grand jury. They're not running them, you guys. That's what we're doing. And if they're not doing it, well, they're kind of fucked then. Kind of fucked. So going back, circling back to where we were right now, right? No, we're not calling for an armed revolution. Absolutely not. This is a peaceful assembly to petition the government for redress of grievances. We are not asking for or calling for any violence whatsoever. Please don't make those statements. Those statements will get people into trouble, get people killed or hurt or unalived. We don't want that, you guys. That's not what we want, okay? We are peaceably assembling to petition the government for redress of grievances. We are following our constitutional rights and authority that we have. If something else is necessary to happen, we will do it consistent with what the law permits, and we will do it within our lawful authority, whatever that might be, okay? So please don't make those statements anymore. I don't want to have to block out this, but please don't do that. Guys, so when Plessy versus Ferguson was being reversed, Brown versus Board of Education, one of the things that happened there was that during that period of time, Dr. King, he was going into a lot of union meetings, right? Down in South Birmingham and stuff. And he would go into these meetings, and the rest of the union members would go into these meetings. And one of the things that they did was they sent state police into these meetings to make statements, statements that would incite violence, statements that could be perceived as threatening, as illegal. And they would do this because they were trying to shut down this movement, the civil rights movement. And they would routinely go in and they would do these things. We don't want that here. We have to be very, very careful about the things that are said on these lives, in these spaces, in these conversations, because there are eyes that are watching these, and they're waiting for us to make statements that would be construed or could be construed as dangerous, as threatening, as terrorist. We don't want any of that. We need to make sure that we clarify on all these that this is an act of peaceful assembly. We are acting within our lawful authority to be able to do that. So let's make sure to keep the statements lawful. All right. So again, going back to the beginning, this is always about the family, because there's a difference between an enumerated right and an unenumerated right. So going back to the 14th Amendment. 14th Amendment, and again, I'm not arguing the validity, we're going to be but the 14th Amendment says that no state shall enact or enforce the law that shall abridge the privileges and immunities of United States citizens. We already went through Article 4 creates certain privileges and immunities that exist. Article 4 does, right? To understand what those rights and privileges and immunities are, you got to do a case called Corrieville versus Washington. This is General Washington's or President Washington's grandson, okay? And it will tell you C-O-R, look it up if you want to know Article 4. But if you know what the 13th Amendment protects us against, well, you can go to a case called Timbs versus Indiana. That's T-I-M-B-S versus Indiana, 2019. Unanimous decision. 6 of the same justices that we have on the court today made this decision. What he said, go read it. What they said is that the privileges and immunities of United States citizens are, at a minimum, those enumerated within the Bill of Rights, given their legal effect against interference by the states because of their codification in the Constitution's text. So if it is enumerated within the first 10 amendments, the Bill of Rights, then that is at a minimum under the 14th Amendment's Privileges and Immunities Clause, right? But it must be enumerated, because that's what the court said, enumerated. It has to be written there. Guys, I've been telling you for a while here that every single one of the 14th Amendment's provisions have all been incorporated except for one. There is one left to be incorporated, and that is called the Grand Jury Clause of the Fifth Amendment. This is the last provision to be incorporated until we go back to 1833 and say, for the United States, Chief Justice Marshall, you committed sedition, right? You're a traitor. Your court's a traitor because you amended the Constitution in other than lawful manner when you told all the courts within your purview that they don't have to obey the Constitution of the United States, that they don't have to give the people their rights that are guaranteed to them under the Bill of Rights. That is Barron versus Baltimore. You guys go read it. That case will tell you exactly that. That's the reason why you don't get indictment today, is because in 1833, the highest court in the land made a decision directed to all the courts within the nation that you don't have to give the people the rights that are guaranteed under the Bill of Rights. Not true, but nonetheless, we have incorporated, because that's the incorporation doctrine, is when the Supreme Court hears and incorporates those provisions. There's one left to be incorporated. Every other one has been incorporated already. The last one to be incorporated is the Grand Jury Clause